League of Women Voters Forum for candidates to the election for judgeship in Santa Clara County Superior Court. I am Phyllis Castle, President of the League of Women Voters of Palo Alto. The League is a nonpartisan political organization whose mission is to encourage informed and active participation of citizens in government. The League does not support or endorse candidates or parties, although it does work to influence public policy through education and advocacy. This forum, funded by the League of Women Voters Education Fund through contributions from members and community donors, is devoted entirely to our voter service activity. Membership in the League of Women Voters is open to both men and women, and you are welcome to join us. This forum and a second forum for candidates for Santa Clara County Sheriff and District Attorney are brought to you by the League of Women Voters of Palo Alto and Los Altos Mountain View. The Sheriff and District Attorney Forum will be held on Wednesday, April 28th at 7 p.m. in the Los Altos Public Library Program Room, 13 South San Antonio Road, Los Altos. Both forums will be filmed by the Media Center and will be aired on our cable public access channels. Watch for the schedule and live streaming on communitymediacenter.net. The Leagues of Palo Alto and Los Altos Mountain View are greatly appreciative for the participation of our co-sponsors: Mid-Peninsula Community Media Center, the Palo Alto branch of the AAUW, the Palo Alto Chamber of Commerce, Palo Alto Online, Palo Alto Weekly, and the Unitarian Universalist Church of Palo Alto Social Action Committee. For more information on the elections, we recommend that you visit smartvoter.org or the League website, lwvpaloalto.org. Please pick up Smart Voter bookmarks. This will help you get to the Smart Voter site, or in a fax for voters out on the League of Women Voters table. And we have pros and cons, which I'll show you at the end. They are also on the table. These are pros and cons for all of the issues that are coming up on the ballot on June 8th. Measures are on the table in the back of the room. Actually, we have some out here. We may have some outside if the weather doesn't blow them all away. And we invite you to please stay after the forum to meet and talk with the candidates personally. I now introduce you to Ellen Smith, our moderator for today's forum.
We have a number of active Ellens in the League. So. Well, I want to thank you for coming and joining us today. Thank you, Phyllis, for the introduction. As she said, this forum is for the candidates for the Santa Clara County Superior Court Judgeship. As you can see from the signs in front of the candidates, there are actually 3 offices, and for each office there are 2 candidates. So you will get to vote for 3 people. You will get to vote for 1 person for each of those 3 seats. And we're relying on you to keep the numbers straight as you listen to the candidates and make your evaluations on who you might want to vote for. The candidates, let's see, before we begin, I want to go over the format of how we're going to do this session. We're scheduled to be finished by 4 o'clock or sooner if that happens. To help keep us all on track, we have a timekeeper who is Relly Davidson, who is sitting here in the front. She will signal the candidates when they have 30 seconds left to speak. She'll hold up a yellow sign, and when their time is up, she will hold up a stop sign. Okay. The candidates have received and agreed to our ground rules for the forum, and we also have some ground rules for the audience. Please turn off all electronic devices that ring, beep, or otherwise make noise. No cameras or photo-making devices may be used during the forum, and no audio recording is allowed. We'll be taking questions throughout the forum. This allows us to cover as wide a range of issues as possible and to be sure that the questions we get are not speeches and are not biased in favor or against any candidate. We have question collectors around the room if they would wave and stand up. Okay, they're available. They have cards. If you would have a question you would like to ask, just raise your hand. One of them will bring you a card and a pencil. Please use these cards that are provided, and you can indicate on the card if your question is for a specific candidate. If there's no indication, we will ask the question of all the candidates. Although there are the 3 separate races, we're going to have a kind of open discussion among the candidates. So again, we need you to pay attention to the office numbers in making your decisions. We have question sorters who are Trina Lovercheck and Carol Stevens, who are sitting in the back of the room. They will be reviewing the questions, grouping them by topic again, so that we can get as many things covered as possible. We're going to begin with a 3-minute opening statement from each candidate. We'll then have questions that we've collected from the audience, and the candidates will each be allowed 1.5 minutes to answer a question. I remind the candidates that your answers do not have to be the whole 1.5 minutes. We might get through more questions if you can make your answers shorter. And then we will conclude with a closing statement from each candidate. They will get 2 minutes for their closing statements, and they will give their closing statements in the reverse order that they gave the opening statements. In the interest of time, and so that we can keep this a nonpartisan environment, we do ask that there be no applause or other demonstrations of support or opposition to candidates or their positions. At the end of the forum, we will thank them all with our applause. The candidates drew their lots, and we have in seat number 1, Joanne McCracken, who is a candidate for office number 7. In seat number 2, we have Bob Kamers, who is a candidate for seat number 19. In seat number 3, Tim Pitzker, who is a candidate for seat number 11. At number 4, we have Thomas Spielbauer, who is a candidate for seat number 7. Number 5 is Vanessa Zecker, who is a candidate for seat 11. And at number 6, Julia Aloggiamento, who is a candidate for seat number 19. So we'll now begin with the opening questions and just the opening statements, and we will begin with Joanne McCracken at number 1.
Good afternoon. Everyone hear me okay? Well, first of all, I want to thank everyone for coming out. It's such a beautiful day today, and it's so wonderful that everyone has come out to listen to the candidates. Many people don't focus on judicial races. They're usually much more low-key than other kinds of races, but actually judges serve a very important role in the community, and who you select as a judge is, I think, a very important job for voters to do. I'd like to give you a little bit of background about myself. I have been a lawyer for almost 24 years. For the first 3 years of my practice, I was in a civil firm in San Francisco and practiced some very interesting, complex civil law there. And then I came to the district attorney's office. And while at the district attorney's office, I spent most of my career prosecuting very serious cases. I prosecuted sexual assault cases for 9 years and convicted some very dangerous offenders, very high-profile cases. And I prosecuted homicide cases for 5 years. After that time, I worked in the community prosecution unit, and I was assigned to work out in the east side of San Jose, going into family homes, trying to work with families to avoid teen criminal behavior, address gang problems, blight, those kinds of community concerns. I then was promoted to chief trial deputy, and I supervised the homicide team and some other teams in that assignment. I'm the first woman in the district attorney's office who's ever served as the chief trial deputy. I now supervise the general felony team. It's the largest felony team in the district attorney's office, and my job essentially is to train younger lawyers on how to be trial attorneys, how to be good trial attorneys. In addition to my law practice, I devote a lot of my time to teaching. I have taught throughout the country, but in particular, I've taught throughout California to lawyers, to scientists, to police officers on relevant legal topics and many other groups. I also do volunteer work. I have volunteered in the area of domestic violence, both for victims and offenders. I have volunteered for almost about 10 years now for the Salvation Army's Adult Rehabilitation Center. It's a group that works to rehabilitate drug offenders, and I have served in some other capacities with rape victims and volunteered in that way. I think that one thing that speaks to my qualifications are my endorsements. I've been endorsed by over 40 Superior Court judges, many attorneys, every endorsing police agency, Police Officers Association has endorsed in my race, has endorsed me, the mayor of San Jose and other mayors, city council members, and so forth. I think what I bring is I will be a fair and ethical judge. I have a lot of trial experience, which will make me a good trial attorney, and I would appreciate your vote. Thank you.
Thank you, Ms. McCracken. We'll now hear from Bob Kamers, who is a candidate for seat number 19.
Good afternoon. My name is Bob Kamers, and I'm, as she said, a candidate for office 19. I'd like to tell you a little bit about my qualifications for the office. I'm a civil practice attorney. I've been practicing here in Santa Clara County for 23 years, and that was my second career. I'm also a retired Army officer from after 20 years of service. I have a very broad civil background. My office was in San Jose when I started out. I did every kind of civil case from personal injury, professional malpractice, construction, breach of contract, trade secret cases, and all kinds of litigation, including collection actions and other sort of corporate litigations. Over the years, I changed my practice to intellectual property, and I also moved my office to Palo Alto, where I've been over on Page Mill Road here for the last few years. I am a registered patent lawyer, and I also do most of my litigation these days in federal court, trying patent cases. Over the years, I've had a continuous commitment to pro bono work. I started pro bono work on basically the time I started law practice. I got the 10-year service award from the pro bono project of Santa Clara County, and I'm now counsel to the board of the Habitat for Humanity of Silicon Valley. I also have a great deal of experience, over 10 years of experience, deciding cases as a court-appointed judicial arbitrator. I've been doing that for over 10 years. I've probably decided well over 20 cases. I'm also an arbitrator with the fee arbitration project here in our county, and I've decided probably a dozen cases with that. So I like deciding cases a lot, and that's the reason I decided to seek a judgeship, because I was getting a lot more satisfaction from doing that than I was really being an advocate. So I thought I'd be better playing that role for the future. In addition to that, I'm just a family man. I live in Los Gatos. I'm married. I have 4 kids, 3 adult daughters and an 11-year-old. And we really love living here in Santa Clara County. I haven't lived here long enough. We traveled all over the world, of course, in the Army, and decided this is the best place to live, so that's why we're here. Let's see. Other qualifications that I have is I've been essentially in leadership roles and a manager of activities and trying to get things organized for over 40 years. So I know how to run things. I know how to be part of a team. And I think if I were to be on the court, I would try to play a role in the organization and other actions of the court to get things going in towards the sort of the goals that I have in mind. Some of the goals I have in mind is that the court needs to take a much stronger role in early settlement of small cases, because the way things are right now in the civil side, if you have a small case, I'll tell you more later.
Thank you, Mr. Kamers. We'll now hear from Tim Fitzger, who is a candidate for seat number 11.
Thank you very much. I have just spent 26 years as a dedicated public servant, working as a deputy district attorney for you folks here in Santa Clara County, protecting victims and trying to get criminals their just rewards. I've done it all. I issue cases, that is, read the police reports and decide what charges should be filed. I do the preliminary hearings, the trials, and the sentencings. I consider myself primarily a worker. I'm a nuts and bolts type guy. I go in and I do the heavy calendars. I get the job done. I have not called in sick since 1989. I help the police out on cases. I go out and I dig up witnesses. I interview and subpoena witnesses myself. I was the first person in the DA's office to use DNA evidence in a trial, a jury trial, to get a conviction. I have spent 7 years handling complex gang and career criminal cases. I spent 3 years in drug court helping to rehabilitate drug addicts to get them out of the revolving door of the criminal justice system. I also spent some time in juvenile trying to help juveniles straighten out their lives and get out of the system. I have had significant contributions to the criminal justice system in California. I'll touch on the most significant one was my Gartley case, which was an attempted murder case, a gang case with a gang enhancement. That case went all the way to the California Supreme Court, and the Supreme Court, with a published opinion, approved of how I approached the case, how I proved the case. I won't get into the details, I haven't got time, but the bottom line is the Supreme Court approved how I proved a gang case, and that case since then has been used to help educate and train prosecutors in the state in gang prosecutions. I believe I am the best candidate, or a good candidate anyway, for judge because I've spent 26 years in court on almost a daily basis. In the last year, actually from January 2009 till February of this year, I actually worked up here in Palo Alto in the Palo Alto courts. And this last year in the Palo Alto courts, I prosecuted defendants charged with attempted murder, rape, kidnapping, mayhem, robbery, carjacking, burglary, weapons, drugs, and a bunch of other stuff. I have a total of 101 felony jury trials in my career in the DA's office. That's more than anyone else in the district attorney's office. And it's my opinion that unless you have lots of felony jury trials under your belt, you're not qualified to sit on criminal cases. I can step right in and take over as a criminal judge, which we need. Thank you very much.
Thank you. We'll next hear from Thomas Spielbauer, who is a candidate for seat number 7.
Thank you. I've been a lawyer for a long time. I've been a lawyer for over 32 years. I'm over 60 years of age. I have a very rich life experience, and my journey through life, particularly as an attorney, has not been a traditional one. It's been one that's been filled with a lot of diverse experiences. But it has given me the wisdom and the ability to sit here before you and to know that I would be a very good selection as a Superior Court judge. Now, I practiced with the Public Defender's Office, criminal law, for about 22, 23 years. I left that, and I have been in a civil practice since then. When I left, I began a civil practice of foreclosure homeowner, foreclosure defense, which was a kind of an interesting time back in 2005 or so, because the whole field has transformed since then. And as time has passed, I saw the pain as we moved into 2007, 2008, 2009. I saw the pain that the collapse of the economy was causing to people, basically my clients, who I would bring before the court. And it's that recognition as the economy changed and as people started to suffer loss, homeowners suffering the loss of their homes, people who are suffering from retirement losses, things of that nature, that made me aware that truly, even though you have the law and the law is fair, a good thought goes into the law when the law is created, it's all subject to judicial philosophy and judicial interpretation. And I saw that very clearly as I practiced foreclosure defense. I would go in with one fact pattern, a similar fact pattern in front of one judge, exactly the same, I'd get one result. I'd go with the same fact pattern in front of another judge, and it'd be a different result. And the only difference that I could see, why were there two different results? It wasn't because there was a difference in the law. It was because of the judicial philosophy that particular person had. And the philosophy that I would bring to the bench is a sensitivity to people, to the people the litigants who appear in front of me, as well as to victims in the event that the case does engender the fact that there may be victims involved. I'm the father of a 12-year-old daughter. I'm very familiar with what it takes to raise a family, particularly being a single parent. And I am very, very concerned about where things are headed with this country. And I think that we need to have somebody on the bench who brings with them a sensitivity to our Constitution, to our constitutional rights, and to the effects of the economy on people.
Thank you. We'll now hear from Vanessa Zecker, who is a candidate for seat 11.
Good afternoon. I have been a lawyer for a little over 22 years now, and I have been a business owner. I've had my own practice for the last 16 years. My practice focuses primarily on issues related to family law. For people who may not be familiar with the family law area, those are issues related to divorce, custody of children, families moving in transition. We deal with issues related to businesses, business valuations, money. I do like to say that in a good economy, people fight about money, and in a bad economy, people fight about money. So my days are spent dealing with and resolving conflict over a number of different issues. Prior to starting my own firm 16 years ago, I began my career as a deputy county counsel. Deputy county counsels defend the county, in my particular area, defend the county, and things like if a bus gets in an accident or a deputy gets into a dispute on the street, the county counsel's office defends those folks. I spent approximately 4 years in the county counsel's office, and I got some good, substantial trial experience there. I also began my love of working with children and families while I was in the county counsel's office. I started work in the dependency unit and quickly graduated to trying long cause trials in the areas of child abuse, child sexual assault, extreme physical abuse, extreme emotional abuse for children. When I moved from the county counsel's office, I moved into private practice, and I decided that my passion really was working with families and the issues that do affect families. I also knew that I wanted a job that allowed me to be in the courtroom a lot, and I certainly got my wish. I spend nearly every day of my life in the courtroom in one way or the other, and when I'm not in the courtroom, I spend my time trying to solve conflict. I have also chosen to move outside a little bit of the family law arena so that I can keep balanced in terms of my perspective, in terms of the entire court system. I devote a lot of my time to pro bono work, which is free legal services on behalf of children. I have also served as a civil arbitrator to keep my balance with respect to the civil side of the courts for approximately 16 years now, since 1994. I also serve as a temporary judge for our courts on the Child Support Commissioner calendars and as a family settlement officer. I also did a 6-month stint in the district attorney's office as a volunteer because I wanted to see how the criminal perspective fit into the world of family law and into my role as an attorney. And I found my 6 months in the district attorney's office to be extremely beneficial because it told me how the criminal system works with the civil system, which works with the family law system. I deal a lot right now with many criminal issues related to domestic violence, parents charged with abusing children, sexual abuse issues, and that type of thing. So I have tried to have a well-rounded career as a private attorney. Thank you.
Thank you. We'll now hear from Julia Alogimento, who is the candidate for office 19.
Good afternoon. My name is Julia Alogimento. As she mentioned, I am a candidate for Superior Court Judge Office 19. For the past 12 years, I have worked as a Deputy District Attorney here in Santa Clara County, and I have handled a number of serious and violent felonies, including domestic violence abuse cases, career criminal cases, and even a homicide. I have been honored during that time to represent the people of the state of California, and one of the reasons I became a DA because I really do feel that it's the place where you get to be an attorney, but your role really is to seek the truth. And I have taken my oath to do that very seriously over the years. In the last few years, I have really had the privilege of working in a different sort of role within the DA's office, and that is one of crime prevention. Before I started that, I had worked in the juvenile justice system. And what I found there was that people were really struggling, especially the parents who were in the system. And they would say to me and to the courts, you know, we know our children are going down the wrong path, but we don't know what to do. And for the last few years, I went out and I've been working in the community. And one of the things I deal with is truancy, or students not going to school. And similarly, in that setting, I heard from parents, I drive my child to school and they walk out the back door and I don't know what to do. And so I kept hearing these cries for help and decided that we needed a program for them. And I started a program called Parent Project. The program itself has been around for 25 years. It's a nationally acclaimed program, but it did not exist in our county. Because I had been working in the community, I was able to collaborate with law enforcement agencies throughout the county, and in fact, Palo Alto was one of the first places that started the class, and I worked very closely with the Palo Alto Police Department. We rolled out the class with one pilot and ended up now, in just about a year and a half, we now have 15 classes throughout the county, offered in English and in Spanish, and we are working on a Vietnamese translation. It's very important to me that we find ways to prevent crime for youth, and I also work on other areas, including the Mayor's Gang Prevention Task Force, and doing a lot of presentations on underage drinking and driving. Before becoming a DA, I worked in civil practice at a large law firm dealing with very complex civil litigation matters, including intellectual property, financial institutions, consumer class action, and so on. I only have a quick time, so I will tell you I have a very strong educational background and honored to say that I have had the endorsements of all endorsing law enforcement agencies, numerous elected officials, the Santa Clara County Bar Associations, and community leaders are supporting me. I was born and raised in Santa Clara County, and I would be honored to continue to serve the community which I grew up. Thank you.
Okay, thank you very much for your statements. But I have some questions up here, please, for the candidates. Okay, thanks for your patience. Okay, here is one for everyone. What is your opinion on applying the death penalty versus permanent incarceration? And as I said, we're going to move in varying order from now on. So the first person to respond will be Thomas Spielberg. Bauer. Sorry.
Well, of course, the death penalty is the law in the state of California. From a personal perspective, I think life incarceration without the possibility of parole can be a worse punishment. Is the death penalty something that I favor? No, it's not something that I favor. On the other hand, it's not, if the jury were to return a verdict of death, I think that it would be my obligation to evaluate that and enter it if appropriate. Sorry. So I'm not sure how to answer that question except to say that from the way I see things personally, I don't think that the death penalty accomplishes much. I'm very concerned, and this was this case up with Judge Fogel, I believe, in the federal court, whether the administration of the death penalty as it exists now through lethal injection is cruel and unusual. But I would follow the law as a judge.
Okay, thank you. You are supposed to have a minute and a half. Are you set, Relly? Is that going to work now? Okay. Next we'll hear from Julia Alogimento.
Thank you. As members of the judiciary, we of course would have to follow the law. That is what our obligation is. So if the law in the state of California is the death penalty, we would of course need to follow that. That being said, I am familiar as an attorney with some of the issues that are raised within that, both procedural and of course for the individual. Prior to my civil litigation practice, I actually was a law clerk. I was chosen for the prestigious position of law clerk in the federal district court in the Central District of California. And in that position, we actually had a number of habeas corpus cases come before the court that involved death penalty cases. And one thing often that people don't realize is it's a very lengthy and complicated matter before the death penalty is ever imposed. And sometimes when someone is seeking the death penalty, they have to think in terms of what is more beneficial for society. And so I think that in looking at the death penalty versus permanent incarceration, that would not be a judge's decision to make. That is usually within the purview of the district attorney's office. And they obviously need to balance a number of factors in making that decision, including what do the victims in that case, what is the proper punishment, and also taking into consideration the societal views of, is this something where we think we will prevent people from doing the types of crimes that lead to death penalty, which are the most serious crimes. Is that time? Thank you.
Vanessa Zecker?
I have a philosophy as an attorney that I would apply as a judge, which is that when I walk into a courtroom, my personal views on any issue are parked at the door, period. So when I am in a courtroom, the only thing that I am concerned about is the evidence that is before the court, my arguments on that evidence, and ensuring that the judge has what the judge needs. As a judge, I would expect the same thing. I would be considering the evidence. If the death penalty is the law, then it needs to be followed. If a jury has decided that the death penalty is appropriate, absent some statutory anomaly, then the death penalty needs to be imposed. If society has decided that the death penalty is not appropriate and incarceration, permanent incarceration is appropriate, then that's what's to be imposed. My personal views have absolutely no bearing on that decision. It's what the law is, and it's what's to be applied.
Thank you. Bob Commerce?
Can I have the question read back? It's been three answers.
Yes, the
and I want to
question
be sure
asked,
I'm answering.
what is your opinion on applying the death penalty versus permanent incarceration?
Okay. We get to state our personal opinion, but first, let me tell you that I absolutely will enforce the law of this state. It's not my prerogative, and it's not my intention to become a judge that puts their thumb on the scale of justice in any way. So that whatever the case law requires, whatever the facts and evidence lead to, whatever the jury determines, that is the guiding light for me as a judge, and I personally think it should be for every judge. I hope it will be. The death penalty is not something that that my personal opinion is going to matter on. I will tell you a couple of concerns that I have about it. After having said I will enforce the law of the state, I think that when you look at it in a fiscal sense, not in a moral sense, but in a fiscal sense, it costs a fabulous amount of money to push for a death sentence as it does to incarcerate someone. It costs a lot less to incarcerate them than it does to try to push for the death sentence, because it goes through so many appeals and so much legal resources are consumed with it. So that's an argument for the voters of the state. It's not an argument for the judges of the state. Thank you.
Thank you. Joanne McCracken?
Thank you. I think that where we lead to the risk of injustice is when judges bring their own personal values or beliefs or biases to a case rather than following the law. And that judges they take an oath that they will follow the law, and whatever the law is in the state of California, judges are obligated to follow it. And if a judge decides he's going to act in a way inconsistent with the law, we run into problems. And so as a judge, as another candidate mentioned, I will put I'll leave my own personal beliefs at the doorstep, and I will follow the law. But one thing that's important when you consider serious punishment, whether it's the death penalty or life in prison or any substantial prison term, is that the case must be adjudicated in a fair and ethical way by a judge who understands the law, who will conduct a fair trial. Because, it's not the judge that makes a decision on the death penalty. Juries typically decide that. But what you need is a judge who's very familiar with law, who's had a lot of trial experience, who understands the rules of evidence, who makes sure that only admissible evidence gets in front of juries so that juries can make fair decisions. And so I think that's a more important concern, is that you have a judge who's qualified to preside over a trial. Thank you.
And Tom Pitzker?
Tim Pitzker.
Tim, it says Tim right here in front of me. My apologies.
I agree with a lot of the comments that Ms. McCracken has just made. I won't repeat them, but specifically in regards to my personal opinion on the death penalty, I'm not going to tell you. This is a totally inappropriate forum to give opinions in regards to the death penalty. It's a violation of the California canon of ethics. And the bottom line is, if we go out broadcasting our personal opinions on a really controversial issue such as the death penalty, if such a case came into our courtroom, the opposite side would try to use that to challenge us so we couldn't hear the case. So I don't want to set up anybody to challenge me on any cases. So you're not going to hear what my personal opinion is. All I can say is I'll be like everybody else is, I will apply the appropriate law on each individual case. Thank you.
Okay. Thank you. From that probably too general question, we'll move to a very specific one. Please help us understand the recent Southern California Palmer decision about inclusionary zoning. Does it apply statewide? And I have to confess that I'm not familiar with this decision. We'll begin with Ms. Alojamento.
Well, I'm sorry to say I'm not particularly familiar with this opinion myself. And so it's hard for me to speak to it if I am not familiar with it. Is there any more specifics that I can discuss?
That's the question. So should we take a pause and ask for some information? Who submit, or if the person who submitted this question, what the situation is? Okay. Should we withdraw the question? Just keep going. Okay. We'll go down the line. Mr. Spielbauer?
Could I have the question read back again, please?
The recent Southern California Palmer decision about inclusionary zoning. And the question is, does it apply statewide?
I'm not familiar with the case. My focus has been doing homeowner foreclosure defense. That has, I think that you can understand that that's kept me very occupied. And I'm not going to venture an opinion on something a case that I'm not familiar with.
Ms. McCracken?
So again, I'll join the ranks of an attorney who does not practice in that particular area. And I think this question highlights how every area of law is very complicated. And what I can tell you is just some general principles of what they call stare decisis in the law. And what that means is if there's a case that's issued by the California Supreme Court, it's the law of the land. If it's the next layer down, an appellate court, if it's in your district, we are in the 6th district in California as far as appellate courts go. It's the law of the land. It governs all of us. If it's from another district, Southern California, for example, another appellate court, then our courts can look at it for guidance, but are not obligated to follow it. And then, of course, if it's from a trial court, then that's just, it's not controlling precedent. So when a judge is making a decision on something, and a case such a zoning issue could come before me as a judge, what I would do is research it very carefully. And I would look at other decisions. I'd look at California Supreme Court decision. Then I would look at any statutory law. Then I would look at appellate court decisions for guidance in reaching a fair and correct conclusion in that particular case.
Tim Pittsburgh?
I've just spent 26 years dealing only with criminal law. I'm not qualified to give an intelligent answer on this question. I'm sorry.
Bob Cameron?
Yes, I don't know anything about this particular case, but I think Ms. McCracken was incorrect about the courts of appeal. If this was a court of appeal decision and there's no other court of appeal decision that contradicts it, that is the law of the state, and every trial court must follow it. If there's 2 court of appeal decisions on the same issue, then every trial court can choose to follow which one it thinks is the most correct. But court of appeal decisions apply statewide unless there's something in the decision itself that limits it in some way, which, since I don't know this decision, I can't answer about that. Thank you.
And Vanessa Zecker?
I'm not familiar with the decision. I will say, though, even if I were, I'm not clear that I would give a position on the thought about the exclusionary zoning principle. I don't think I would give a position on that because that is an issue that could end up in my courtroom at some point. And I don't know how I would feel about it, and I think we want that. I don't want any preconceived notions. So my opinion on whether it was a right or wrong decision, without knowing anything about it, but even if I did, I probably would not have given a thought on that.
Okay, we'll move into another loaded question. Since so much of a Superior Court judge's workload is criminal, how important is it for a judge to have had substantial criminal law experience? And we'll begin this time with Bob Commerce.
Well, I sure think it's important and useful to have a criminal experience. And so I'm doing a lot to acquire the experience I can. Already started researching on the criminal law and whatnot. It is important to have knowledge of the evidence code. The evidence code, it turns out, is the same for civil and criminal, with some exceptions. In addition to that, I could say for myself that as an Army officer for 20 years, I enforced the law. It was military law. It was the federal rules of evidence. But nevertheless, I get the concept that you need to use the criminal law to prevent violent crime. So, yes, I agree that criminal law is important. A lot of the judges that get appointed by the governor are civil judges. They're put into criminal law departments, and they work there they work under the supervision of another judge. They're tutored, so to speak. They pick it up, they learn it, and sometimes they decide to specialize in it. So I don't think it's absolutely necessary. I think it's very useful, and I think it's especially useful in the first 5 years. Thank you.
Ms. Decker?
I don't know that I agree with the initial premise that the majority of our cases are in the criminal court system. 20% of the cases in our system are family law cases. Right now, out of the 80 judges, 10 are sitting in family court. We need 16 judges in family court to properly serve that caseload. So if I'm sitting in my chair with 20% of the cases being in family court, I would love to see the judges who come through family court have family law experience. We don't get that very often. We have 4 of our current sitting judges who have a family law background. That's it. So we are used to in family court having to help judges learn family law, learn the culture of family court, and get them up and running as family court judges. I would fully expect if I were assigned to a criminal department that I would learn the criminal law, criminal procedure. I'd enhance what I already know, and I would assume that I would learn very quickly the criminal law culture. So nowadays we cannot be experts in all areas. The law is far too complicated for that. So I do believe criminal experience is important, but I also believe family law experience is important and civil experience is important, and that we have a diverse bench with people with all kinds of experience.
Thank you. Ms. Alojimento?
I do think it's very important that the judges have criminal law experience. I do believe that the majority of the cases are criminal, just by the nature of how our courts are set up. And I had a question before this started by someone. A judge can be assigned to any court, and the majority, like I said, are going to be the criminal courts. However, there are also civil, family courts, and juvenile. And so I think ideally you have a judge who can handle any of those areas. And given my broad background, I'd be able to do that. Within the criminal courts, a lot of people also don't know this, only about 2% of the cases actually go to trial. And so one of the things that's really important is having a judge who has years of experience handling very complicated criminal cases to be able to properly evaluate that case and assist the attorneys in settling that case. And then, if the case does go to trial, to have the knowledge to make the proper evidentiary rulings during the trial so that the jury can make the right decision. And then finally, to have a good basis to evaluate, if a jury does come back guilty, to evaluate what the proper sentence is. Because while there are sentencing guidelines, it is up to the judge to decide the sentence in the case. And so having, over a decade of experience within the criminal courts, you can better evaluate whether this is an individual who may need to be removed from society to keep society safe, or someone who really would benefit by having some form of rehabilitation and reintegration back into society.
Thank you. Ms. McCracken?
I actually had the occasion to study this for the district attorney's office. I was assigned the task of studying how many cases, the ratio of cases, criminal and civil, and in fact it is correct that the vast majority of cases that are in Santa Clara County are criminal cases. And the purpose that I was studying it for was to figure out ways we could be more efficient and move cases more quickly through the system, because you've often heard justice delayed is justice denied. Is it essential that you have a criminal law background to be a good judge in criminal? I don't think it's essential. I think that if a judge is committed to learning criminal law, I think that even a judge with a civil background can be a good judge in criminal cases. I can just tell you anecdotally, generally criminal lawyers prefer to practice in front of judges who know criminal law. And what's the reason for that? Well, it's a complicated area of law. There's a lot there, and it's just more work for the lawyers if the judge doesn't know certain aspects. Actually, the evidence, the law, rules of evidence are quite different in criminal cases. And so a lot of lawyers feel like, well, now I have to educate the judge on this aspect because the judge doesn't have that background. If you have a judge that's willing to learn and work hard, then that's fine for the attorneys. But it's a little bit more work. But is it necessary? No, I wouldn't say that it's essential. It's just helpful in criminal cases.
Thank you. Mr. Pitzker.
In our county, most newly appointed or elected judges start out with criminal calendars. It's been my experience, it takes generally 3 to 4 years for a non-criminal attorney to come up to speed, which means that person needs a lot of help. So of course it is much better to have someone who has extensive trial experience, who can jump right in and take over a calendar and a caseload without having any training or any support from anybody else. Thank you.
And Mr. Spielbach.
Could I get that question reread, please?
The question was, sorry, to the right. Since so much of a Superior Court judge's workload is criminal, how important is it for a judge to have had substantial criminal law experience?
Well, first of all, I don't agree with the presumption that so much of a judge's workload is criminal, because there's a wide variety of cases that come before the Superior Court. But even if we assume that there is a large caseload, it's helpful to have criminal law experience. I think most of the people here at the table have had criminal law experience, but it's helpful, but it's not at all critical. And, you look at, you want to call criminal law complicated? Sure. You want to call family law complicated? It is. You want to call civil law practice? That's very complicated. And Mr. Kelmer is here to practice patent law. I'm willing to say that that's very complicated too. And so no matter what area of law, although that's federal, I believe it is patent law, but no matter what area of law you go into, it's going to be complicated, and no one judge can be an expert in all areas. And what is probably more important is two things. One, how much of a quick learner will the judge be? How motivated will he be or she be to come up to speed on the law? But there's another part of the equation that really hasn't been mentioned, and that is the role of the lawyers in appearing in front of the judge. That is, hopefully you'll have lawyers appearing in front of you who will know what they're doing and know the practice of law. I can just tell you, as a lawyer who has appeared, basically, if you want to call it a niche practice, call it that, but homeowner foreclosure defense. There's not a lot of knowledge in that particular area. So when I come up in front of a judge, I know that part of my job is to educate the judge as to the law. That goes with part of the territory. I would expect that if I get into an area, suppose I get put into family law, I would expect that kind of approach from the lawyers appearing in front of me.
Thank you. Our next question asks, we hear about overcrowding of prisons, yet we don't necessarily feel any safer. What are your thoughts about preventing people from entering the criminal justice system and your courtrooms to begin with? I think this is really a philosophical question for you. And we'll begin with Mr. Pitzker.
Oh, yes. I mentioned that before in my opening statement. To help the system out, we need to rehabilitate the drug addicts, to get them off their drugs and to be productive members of society, and that alone would be a huge, huge help. It reduces the crime, it reduces the cost to the taxpayer. The other approach or other aspect that can help out a lot is you need more intervention at the juvenile level. So many kids, by the time they're 16, are hardened criminals. You need to work with the kids to get them motivated into the right frame of mind to be productive citizens, to work for a school or whatever, but just simply to get them away from the gang mentality and all that sort of thing that's so prevalent in the teenager's life today. Thank you.
Ms. McCracken.
I think that crime prevention is a really important issue, and it's something that's important for a judge to consider and take an active role in that. I think that some of the things have already been raised that are important for that. Rehabilitation of drug offenders, and as I mentioned, part of my personal volunteer work has been in that area, because I see how drug addiction can lead to theft, can lead to burglaries, which are considered violent offenses, and so forth, robberies, those kinds of crimes. So try to nip it in the bud by being involved in that kind of work. It's also very important to do work with juveniles, because it's true, it's scary to see it from this perspective, but by age 15 and 16 you can see teenagers who are firmly entrenched in gang lifestyles, and that leads to future criminality. But it's also important to work with families, because you have many families who have difficulties with raising their children so that they're not involved in gang lifestyles, and then they don't go down that path. And I think that some of the work that I've done in the area of truancy and working with families has shown a commitment to that. But a judge needs to bring all of those perspectives in, because the answer is not necessarily in every case, lock them up and let's throw away the key. Judges who understand and are familiar with these issues can do things much earlier in the process to keep us all safer in the long run. Thank you.
Thank you. Mr. Spielbach.
I'm going to have to kind of give a disclaimer. These are my personal views and in no way reflect on how I would deal with things as a judge. The first question you have to ask in regards to crime and prison overcrowding, that kind of thing, is what makes it a crime? Why is something a crime and something not a crime? Because it's been declared to be such. And I think that if we take a look, reflect on what our laws are and what we have decided will be crimes and what should not be crimes, and what should send people to state prison, will have a dramatic impact on prison overcrowding. I'm very much a believer in the fact that, you know, people, hardened criminals, those who perpetrate violence on other people, those who cause catastrophic financial loss, such as ripping off people who invest and they get ripped off, things of that nature. Yes, they're the ones that are deserving of incarceration. But when you start to look at some of the softer, if you want to call it softer crimes, such as, say, drug possession, marijuana possession, things of that nature, I think we need to reflect on whether do we really want to continue making that criminal, or do we want to take another approach, which in turn would definitely alleviate prison overcrowding.
Thank you. Ms. Secker?
I think until we deal with the reasons why there has been such a breakdown in the family dynamic, we as a society are not going to feel safer. And that is just, I believe, from the work that I do in our family court system with the collateral connection to the criminal justice system. We are seeing a breakdown of the family in a way that is not good. We are seeing parents who are allowing children to parent themselves. We are seeing generations of children raised with a lack of accountability and an entitlement mentality. And when we have a lack of accountability, that leads to folks believing that the law is not something which needs to be followed, but which is something that can be gotten around because somehow I'm special. We see children who are raising themselves and then become involved in gangs, become involved in crime. We see children who are raising themselves develop drug problems as early as 10 or 11 years of age. That's my world. So as a society, until we figure out why the family is breaking down and how we can support the family in addressing the needs of children, I'm not sure we're going to feel safer as a society, and I believe the prison overcrowding is going to continue.
Thank you. Ms. Alojimento.
I actually agree with what was just said and what we're seeing, because that's exactly what I was seeing in the juvenile justice system and in our community throughout Santa Clara County. If you start with prison and work your way backward, unfortunately, the majority of people who are in prison started out as juvenile offenders. Majority of juvenile offenders started out as truants. And in fact, there's a statistic that 80% of people who are in California state prison were truants. which means we have to be starting with the youth. Not only in getting them back to school, but really with giving their family support. And that is why we started a parent project, the program I talked about earlier. And I can tell you that of the 600 families that have graduated out of that program, we have actually seen phenomenal results. And I personally go to quite a few of the graduations, as many as I can attend. And parents who have put their kids through other programs, other services, and gotten the results are finding results as soon as they learn how to do it. They have their children, one parent told me how their child was finally drug-free for 45 days after graduating from this program, despite that no other program had had any effect on him. I've talked to parents whose child finally got out of gangs. And what that is teaching parents that they have to be the ones who are accountable for their children. They have to have some accountability, but also they have to have the tools and the love and the support of their children. And what we have found is if we work with the families and the parents, that the parents will, in fact, make those changes of their children. Is that fine?
Thank you. Mr. Commerce?
Well, I think the real question here is, what about the role of a judge with respect to this question? I agree with almost everything everyone said, but the real question is, what should the judge do? So I look at our courts right now. We have a drug court here. You may not all know that, but that is a court that's oriented on dealing with drug offenders and primarily or often sending them into diversion and rehabilitation. I know because I've talked to some of the judges that sit there that this changes people's lives, and I'm very encouraged by that. But more than that, I think that the role of a judge in our county and our society is the role of a leader. It's someone who influences others by the position they hold, the things they say, the positions they take, and the structures that they help the community set up to deal with serious problems. And so I think that that's something judges need to do. What exactly I would do, I'm not in a position to say right now, except that I think that the role of a judge is a leadership position and to help the community deal with these procedures, even though it's not the, in other words, the court isn't going to decide anything. You're not going to be deciding things as a judge on these community measures that need to be taken and done, but you can influence other people to do it because you hold an influential position in the society. Thank you.
Okay, thank you all. We have a question that follows on to that. Are the girls and boys ranches run by the county still effectively used with good results? Expand your comments as appropriate. And we'll start with Ms. Zecker.
In the family court system, we have some collateral issues related to the girls and boys ranches. I look at the situation where I go back to a little bit of the previous question, which is where I would prefer to deal with the issues prior to these kids being sent to the ranches. I have somewhat of a philosophy that I think when kids are sent to the ranch that they mingle with other kids who have the same sort of backgrounds that they do. And sometimes that can be harmful. So rather than being raised by a family, they're being raised in an environment where they're exposed to other folks who have, young people who have committed crimes. So I'm not sure I take a final position on whether or not the girls and boys ranches are effective. It is a sentencing alternative. That's what we use. That's what we're supposed to use, and it will be followed. But I do sometimes question the wisdom of putting a lot of young people together in that type of setting without a whole lot of parental involvement.
Mr. Pittsburgh.
Yes, the boys and girls ranches are a very essential part of our system in this county because for two reasons. Number one, you need the punishment for these juveniles because if you didn't have some kind of punishment, they'd be totally out of control. So you need it from that aspect. Second aspect is at the ranches, they have programs for the kids that help them straighten their lives out. So if a kid can be motivated to rehabilitate himself, the opportunity is there. But it basically comes from the heart of the kid. If a kid doesn't want to be rehabilitated, there's nothing you can do for him. But you can provide opportunities for the kids that are willing to make the effort, and from that standpoint, the ranches are helpful.
Thank you. Jen, are the girls' and boys' ranches still effectively used with good results? Expand on your comments as appropriate. And we'll go next to Mr. Commerce.
So I've made it a practice over the years not to make comments about things about which I know nothing, and I know nothing about this, so I will not make any comment. Thank you.
Okay. Ms. Alojamento.
I worked with the ranches quite extensively when I was in the juvenile justice courts, and what I can tell you is, unfortunately, in the juvenile justice system, we have somewhat of limited options. So you can send a child home, you can put them on the probation, you can put them in juvenile hall, or you can send them to the ranch. And unfortunately, there are some very serious crimes being committed by our youth where it is appropriate to, for a portion of time, remove them and ideally give them some sort of services to hopefully rehabilitate them. And that is at least the goal of the ranches. Right now, what I was finding is that for a lot of youth who go through our juvenile justice system, they do fine when they are getting services. They actually do turn it around. The problem is quite often when those services end, they kind of will go back to their old ways. And again, that is why I feel so strongly that we need to get the parents involved and get the families involved. And if they have the tools, then we have much better results. If the parents can be doing it at home, then they are able to make the changes. But we do have to have something for the juveniles, because if we are not giving them some sort of accountability and they continue doing those very serious crimes, then when they turn 18, they're going to be going to prison. And that doesn't help out anyone. That doesn't help our society. That doesn't help that child. So you have to find some balance of accountability and resources. And currently I am actually working with the ranches to see if we could bring our parent project program to the parents of the children who are in the ranch, so that when their children return home, they'll know how to handle those issues.
Thank you. Mr. Spielberg?
That's a very, very tough question, which I don't think I can give a satisfactory answer, because you look at the alternatives. The alternatives are home on probation, again, going to the ranch and doing time in juvenile hall. But there's one other option, and that's sending the kid to the California Youth Authority. And so if you have a situation in which home on probation doesn't seem to be a viable alternative, then you've got the ranch or some time in juvenile hall. So which of the two is better? Certainly the most extreme resolution is sending a kid to the California Youth Authority. So, you know, I don't know that I can give you a satisfactory answer to your question.
And Ms. McCracken?
I think that one of the things that's important to consider when we talk about juvenile justice is that we start out, depending on the juvenile and depending on the crime, of course, with a lot of things that are directed toward rehabilitation rather than directed at punishment, like restorative justice. And that's where the community, the juvenile meets with the community, and the community neighbors actually decide what the punishment is going to be. And it might be something like write a letter to the person that you hurt and pick up trash. And then we might move to the next level. There's a deferred entry of judgment, or there can be time spent in juvenile hall, and there's all these things. And one of the things that is promising is as we go through each level, a certain group, a certain percentage gets rehabilitated. But then there's the next level that doesn't at that level, that doesn't get rehabilitated. And so we move on to more serious punishment. And the ranch is the most serious punishment before the youth authority. And so when we send children to the ranch, we have to keep in mind that the next step would be that they go to the youth authority, which is really just a prison for juveniles. And I think that the gang involvement and those problems that are present at the youth authority are very serious. But I think it is promising that many children who go to the ranch do leave that, and that's the end of their criminal career. But I think that some of the important things that have to be considered have already been stated here. Rehabilitation is an important goal for juveniles, but also holding juveniles accountable, because juveniles can and do commit very, very serious offenses sometimes. Thank you.
Thank you. We clearly have a great deal of interest in crime prevention and juvenile intervention in particular. I have some more questions. I'm going to try to put them together into a single opportunity for you to talk on this subject once more. It's a question about the role of juvenile probation officers and whether they are overworked and able to do a decent job. Many people on death row were abused as children. What about early childhood intervention? And what would be the most successful experience in helping a dysfunctional family to become better functioning that you can describe? So again, how can we better deal with situations that begin in childhood? What role can the courts and the justice system have for such families? And we'll begin with Ms. McCracken.
So let's see, that's a broad question. There's a lot there. So I'll just talk for a minute and a half about the way that I see the system. I think that every aspect of our system is overworked. I think that the juvenile justice system, really every aspect of our justice system is really at the point where you almost can't imagine that they can take another case. And part of that has a lot to do with the economy and lots of other factors. But that's why it's so important to focus on rehabilitation. And as those who have asked the question clearly recognize, we have to work early at avoiding criminal behavior. And we see now, we know this, that it starts very early in life with families. And so there's so many layers to get to make sure that when in our dependency unit, if a judge is assigned to the dependency unit, that you make sure parents get the right skills so they're not abusing kids when their children are 5 years old, because those kids end up in the juvenile system, and then those kids end up in the adult system. So it's breaking the cycle of abuse, breaking the cycle of violence, and trying to find appropriate ways to heal families and heal these children so they don't end up in the system later on, or so if they do end up in the system, we make the time they spend in there as short as we can. Thank you.
Mr. Commerce?
Well, it seems to me like the solution to these issues is really not in the courts per se. Certainly, certain departments of the court will play a very large role in this, the juvenile departments, the family law departments, and whatnot. I think that, I'm just going to return to my prior answer, really. This is there are agencies and groups within our community that will be able to do far more to deal with these problems than the judges that are sitting in the Superior Court. Nevertheless, the role of a judge as a leader and a motivator can assist the groups that are out there to do things about it much more than any effect that they're going to have while sitting on the bench. The other thing I think for us all to think about as voters and taxpayers is that all these services have to be paid for. So, well, if we're willing to pay for it, then we could probably get it. But if we're not willing to pay for it, we can't get it. So I think we all need to think about how to get more tax revenue in there so that we can pay for the services that we really need. Thank you.
Thank you. Ms. Decker?
So juvenile probation officers are overworked because they are standing in the shoes of the parents, right? The parents are the ones really who should be ensuring that the children are doing what they're supposed to be doing, but the parents are somehow not available and the probation officer needs to step in. In family court, the epic of the dysfunctional family is probably what we deal with the most. I represent a lot of children in family court who come from dysfunctional families. These children are quite candid in terms of what the situation is at home. Their parents are fighting. Their parents are using drugs. Their parents are not at home. Their parents are allowing them to have free reign. Their parents are fighting so badly that the children are not being paid attention to. That's what I see in my world. And until we figure out how to deal with the dysfunction in these families, we are not going to solve the problem. Family court, and in particular family court judges, can help tremendously in that area. We are starting some pilot projects in family court that give significant and firm intervention into the family from the beginning. So when these types of cases come in, minors counsel will be appointed more frequently, early and often, and therapeutic intervention into the family to figure out why these parents cannot raise their children and why they're fighting all the time, such that the children are getting lost in the mix, to break that cycle of dysfunction. One thing we do know is that when children are abused, they do grow up to be abusers unless the cycle is broken.
Thank you. Mr. Pitzker?
This really is an unfair question because you're trying to ask us how we're going to solve society's problems, and I don't think any of us are really qualified to do that. But, and I don't disagree with anything anybody's said so far. The bottom line is it gets back to family values. You gotta prevent or help prevent the breakdown of the families. And the bottom line is the courts are not set up to keep people out of the system. We can help people to a certain degree once they've gotten into the system. But the judges are not social workers. Our job is to make sure the law is applied evenly and fairly to everybody that comes through the system, and we can try to help. But we're not there to solve the problem. We can't do that. It's not set up to do that. Thank you.
Ms. Alojamento.
I can tell you, I work very closely with the juvenile probation officers, and they are incredibly overworked. They've been cut, and I work really closely with the schools, and every school is saying that if we only had a probation officer who could be at the school site, which they used to do, things would be better. We know they would, and they just can't because they are in court writing papers. And so to answer that question, yes, they are overworked, and it's unfortunate. In terms of what programs to get to early childhood intervention, I know I've talked about it quite a bit, but I will say that, again, if we can address it with the families, that is our best ability to change behavior. The program that I started, the Parent Project, started as a program where I was looking for just people to voluntarily be in the program because there was such a need for it. But it was getting such great results that both family court judges and juvenile justice judges and truancy court judges are now referring into the program because we have seen those changes. And while I don't necessarily think it's the role of the judge, certainly not in court, to be a social worker, I do think that there has been a big push, and it's appropriate for judges to have familiarity with what the issues are in our community, and to the extent that judges can do outreach or recognize those issues and direct some changes, it's appropriate for us to use our position to do that, not as an activist, but someone who has the knowledge of the issues and the system. What I can tell you is we have faced cuts, enormous cuts in our city and our county, and prevention always gets cut, but we have to work on that for our youth.
Mr. Spielbauer.
I guess my thought is by the time they come into the parents come into the criminal justice system, it's awful late in the game, and the damage has been done. What can the court system do to remedy the situation with abused children? There is a system set up to come into potentially dependency court. But then we run into the question, if we have a lot of intervention which is intended to try to fix dysfunctional families, how much intervention is there, and how invasive of a society do we get that is going to invade family values and the operation of the home? I guess if I had to, say, write a prescription, what is the best way to deal with this situation? Here I go betraying how old I am. I remember the days back in the 50s where religious organizations played a very substantial role in the communities that they were a part of before the state intervened. If there were issues, the religious organization would attempt to try to provide assistance and help. But as the broader prescription as to what the juvenile court, the criminal court system can do, or the justice system can do, I don't know that there's a lot. I certainly, in the days of when I did criminal defense, I saw the horror of abused children growing up to be adult defendants. And you see the acts that they did, it wasn't good, but you see the horror that they suffered as children, and that was troubling. And so I don't have a prescription or a resolution to that particular question. I don't know that there's an answer within the justice system.
Thank you. Now we'll move to something much more judicial. What is your view on instructing a jury concerning jury nullification? And we'll start with Mr. Pitzker.
I don't believe, well, the judge has to instruct the juries on the applicable law. And I'm not aware of any jury instruction that directly applies to jury nullification. So I don't think that that's an instruction that should go in front of the jury. And as far as my opinion of, actually I think this is one area where I think I can give a little bit of an opinion. I'm very much against jury nullification. I think the jurors are obligated, and the law states that they're obligated to follow the instructions that the judge follows. And if they don't follow those instructions and decide they want to throw in their own feelings of what the law should be, they're not doing their job as a juror. And if every juror decided they could do whatever they damn well please, then we would never have any justice in the jury system. So those are my feelings on that.
Okay, thank you. Ms. McCracken?
Well, there is no jury instruction on jury nullification. Instead, it's the opposite. Jurors are told that they may not nullify, and essentially the way they're told that is they're told that they follow the law. They must follow the law. Jurors, in fact, take an oath that they will follow the law even if they disagree with it. So when we see jury nullification, which happens sometimes, at least the way that we refer to that term in the criminal justice system, it's a case where maybe because the jury didn't like the victim's background, or the fact that the victim had some tattoos, or was, we used to see jury nullification in rape cases in the 70s because the woman wore too short a skirt, and so we're not going to follow the law because maybe she brought this on herself. So jury nullification starts to get into dangerous areas, and judges are obligated to instruct juries not to nullify, and they are to take an oath to follow the law. And if they have such strong feelings about a particular kind of victim, or a particular kind of defendant, or a particular kind of crime, they're supposed to tell the judge that during the jury selection process, so that a case where they don't bring strong personal biases is a better case for them. So as a judge, I would follow the law and instruct the jury to do the same, separate from whatever personal feelings that I have.
Thank you. Mr. Spielbauer?
I think I better give this as my personal observations as to what I would do as a judge. I'm in favor of jury nullification. Jury nullification has a constitutional basis. The whole concept of jury nullification is that the citizens will determine whether a particular law should be applied or not. It's constitutionally based. You're not going to find a California statute or even a federal statute that calls for it, but it's based on constitutional principles, which is the ultimate law of the land. Now, the interesting thing that nobody has bothered to talk about is that when you get called as a juror and you go through the voir dire, before you hear anything, not even the jury instructions, not even the law, you will be asked to take an oath that you will follow the law. My question to you is, how can you take an oath to follow the law when you don't know what the law is that you're going to be told to follow? Now, we remember the good old days of slavery and Fugitive Slave Act and that kind of stuff, where it would have been illegal to harbor runaway slaves and that kind of thing. Well, that was the law of the land. Now, what would you do if you're sitting on the jury and you've taken this blanket oath to follow the law, but you're not told what the law is, and now you're asked to find this person guilty of criminal behavior because he harbored a slave? And so I go back to the point of saying, from a personal perspective, I think, and to say finally that somehow or another if you have jury nullification, juries are going to go crazy and just let everybody go and go wacko, that's an ultimate insult to the jury system. The ultimate insult, because it is within the jury system that we place our trust that justice will be done.
Thank you. Ms. Zecker?
I don't believe that a specific instruction saying to the jury that you are not allowed to engage in conduct consistent with jury nullification is going to do any good. Jurors, I have a tremendous faith in the jury system. People are people, and if they are inclined to do something like that, then they're going to do it, regardless of the instruction. That particular instruction is not going to make any difference. As to my personal opinion, whether I agree with it or not, it wasn't part of the question, but I probably wouldn't tell you anyway. So from my perspective, those types of instructions are meaningless in the context of human beings sitting on a jury who are likely to do what they believe is right anyway. Not necessarily that jury nullification is the right thing to do, but I think an instruction on that issue is probably not going to assist.
Mr. Commerce?
Thank you. Yes, it's just absolutely clear that the jury instructions, at least in civil cases, are that the jury must follow the law and follow the law that they're instructed by the judge. And we're the ones that give the instructions. And so when you get an instruction to follow the law, the concept of jury nullification is that, well, gee, I'm not going to follow the law. So that's the opposite of the instruction that you give. And so I wouldn't see any point for an additional instruction telling you you can't do that, and there's already instruction that you have to give that you can't do that. So I think for most of us, that's the end of that. Thank you.
And Ms. Alojimento?
Yes, for those of us who have pretty extensive trial experience, we know pretty much how this works. The jury instructions are really based on a lot of attention that goes in prior to the jury's receiving those instructions. So there are a lot of practices put in place to make sure that juries do reach the correct result and do follow the law, because that is their obligation. If someone wants to go change the law, there are means to do that outside of court. It's not appropriate necessarily come into court and think you are going to change the law. Jurors, we go through a process of voir dire with the jurors so that attorneys have an opportunity to see if there's some bias, and if they feel that someone is biased, they can excuse that juror from serving, and judges even can excuse if they feel that it's strong enough that they can excuse them for cause. Aside from that, when we get to the jury instructions, those are determined by both attorneys in the case, the prosecution and defense, or the plaintiffs and the defense in a civil case, and the judge, all looking at those instructions and making sure that they are fair. And then when they are read to the jury, there's actually been a movement recently to make them a little bit more plain English, because sometimes they are difficult for the jurors to understand, but there's been a movement to make them understandable. And I think with all those precautions in place, we really do end up with the right result most of the time from our juries, because if we can have them understand what their role is and their duty is, then most jurors do take that oath very seriously and come to the right result.
Okay, thank you. We have time for one more question before we move to the candidates' closing statements. And this question asks you for your opinion of the current 3 strikes law. And I think you can speak to it personally or as law, or the impacts that it has on the system. And we'll begin with Mr. Spielbauer.
Well, the long and short of the 3 strikes law, it's there. It's going to be there for a long time. But I think that judges need to have the discretion as to whether or not they should apply the law or not. And, you know, each case comes before you can have a case in which the DA can charge a case to a certain, charge a particular crime. They can overcharge, they can charge appropriately, or a plea bargain can be reached. But I think that a judge has to take into account the circumstances surrounding the crime, but also take into account the circumstances surrounding the defendant. And we kind of roll back to the question that was brought up previously about abused children and how they end up in state prison. In my work as a defense attorney, I've seen exactly that, where I had a defendant who had previously committed a very serious crime, but he had one of the most horrific childhoods I'd ever seen. So when he came back up for possession of some methamphetamine because he did something stupid in a JCPenney store, he was a 3 strikes candidate, and he went away for life. And I think that a judge needs to take into account the circumstances surrounding not only the current offense, the underlying offense, but also the circumstances of the defendant. So the short answer to the question is the judge needs to have discretion.
Thank you. Ms. Alojimento.
The 3 strikes law is the current law, and of course, again, as judges, we would be required to follow the law. But what a lot of people don't understand is the full ramifications of the law, or the fact that there is discretion built into the law, and that is appropriate so that people make the right decisions when either charging those cases or ruling on those cases. And what I think you want is a judge who has strong familiarity with those cases and has tried those cases to understand that. In 3 strikes law, we are talking about serious and violent felonies, and when it comes to the 3rd strike and making the decision, judges do have some discretion. They have discretion to strike a strike. It's called a Romero motion. And for a judge to look at that, they must consider a number of factors, and they're going to consider what were the original felonies that led them to this Is this someone who, again, is going to victimize other people in our society to the extent that we do need to remove them from society? Or are there unique circumstances to the crime? Maybe it was so long ago, maybe it was a juvenile strike, that it's really not appropriate to remove them from society. So again, what you want is a judge who has seen a number of these cases, has practice in that, and can put it within the context of proper framework to make those decisions, because judges do have discretion in that case. And so I think that we are required to follow the law, but it is appropriate that judges have discretion within that law.
Thank you. Mr. Commerce.
Thank you. Well, I certainly can agree with Ms. Alojamento on the process. The judge's role in it, as I understand it, is that the judge has discretion to remove a prior to affect the outcome on proper motion from counsel. And when you're presented with a motion like that, you have to look at the prior convictions, the age of the prior convictions, the nature of the prior convictions, and so forth, and make a decision based on the evidence and the law. And of course, like all of us have said, we plan to follow the law. We will follow the law. The one thing I will say is that I will always be thinking about the victim and potential future victims, because I think that the role of the judge, we're dealing at that point in the process, you're dealing with someone that's been convicted, and convicted more than once by a jury of his peers of something quite serious. So it's completely appropriate, and what my intention would be to be focused on potential future victims and the duty to protect the community while deciding under the law and facts. Thank you.
Thank you. Ms. Zecker?
I think the three strikes law was passed because of the public's frustration with the criminal justice system. And some of the problem that we're faced with is that when a person commits a crime, that's one time. We would hope that that person would learn from his or her mistakes and move on to a crime-free life. But we have repeat offenders and people who come back and do it again the second time. And then the public says, okay, the third time, I think we're done with it. I think that the three strikes law was in direct response to the public's need to feel that it had some control over the criminal justice system. I do believe that judges are given enough discretion under the current three strikes law to ensure that a truly bad result does not occur. I also think that the law has given the voice to victims in a way which is good, which is that we say, we'll give you once, we'll give you twice, but the third time, we're just not going to tolerate it. So it is not a law which does not give chances. It is a law which sets limits and boundaries. And I believe that's really what the public was trying to accomplish.
Ms. McCracken?
So you all probably recall that the three strikes law was enacted in part because of the kidnapping and murder of Polly Klaas by Richard Allen Davis, and the public's outrage that if that three strikes law had been in place before, then Richard Allen Davis wouldn't have had the opportunity to kidnap and murder Polly Klaas. And so the three strikes law has been very effective at incarcerating career criminals who have committed serious or violent felonies. That's what the law is directed to. But we discovered after the law was enacted that it also included in its broad net people who might have committed less serious offenses. They had serious offenses way far back in their background, but now after a long period of rehabilitation, stole a slice of pizza or got caught up in some drug offense or something like that. And so the law was changed to allow judges discretion. I served on the Three Strikes Committee as the chief trial deputy in our office, and so I was charged with the responsibility of deciding, is this a case that we should apply three strikes law, or is this a case where we should not apply the law? And the district attorney is given that obligation, and I was charged with that responsibility in our office. And so those are the same factors that a judge would decide. When do we apply it fairly to protect the public and protect victims? And when do we apply it and say, now we should not use it in this case because it's not appropriate given who the defendant is and the nature of his crime? And so I think that we need judges who have experience in studying those issues and a lot of experience in studying those issues and do so fairly.
Thank you. Mr. Pisker?
This is actually a subject that I'm well qualified to talk about. I told you earlier that I had spent 7 years doing gang and career criminal cases. Well, career criminal cases are mainly three-strike cases. I'm the one who gets the cases for trial after Ms. McCracken and her teams decide which case goes forward as a three-strike case and which case gets reduced. I will not give you my personal opinion on the three strikes law. However, I will tell you that the DA's office considers it a very valuable tool, and Ms. McCracken was correct that since the three-strike law went into effect, there has been a very, very significant reduction in serious crime because those criminals have been off the streets. Now, with that said, I have to point out to you that 50% of all cases that come through the office that are eligible to be charged as three-strike cases and subject to life have been reduced by Ms. McCracken's team. 50% of them don't even get charged, well, they get charged but get reduced. So they don't, 50% off the top don't have to worry about going to prison for life. The other 50% goes to people like me to prosecute those cases. We go through and we prosecute them. Some go to jury trial. Most of them get settled by the judge. Of that 50%, a majority of them are reduced by the judge so that they're not subject to life in prison. So the net effect in Santa Clara County is less than 10% of all the people who could have been sentenced to life are actually even sentenced. So all I can say is that in Santa Clara County, the three-strike law is applied very carefully, and there's a lot of discretion used, and only the really serious people get shipped for life. Thank you.
Okay. Thank you. We'll now go to the closing statements. A reminder that each candidate has 2 minutes, and we will hear from them in reverse order of the opening statements. And I'll remind you in the audience that once again, you have the opportunity to vote for one of the 2 candidates for each of the numbered seats. So keep your eye on the numbers as well as the speakers and helping you to make your choice. And we will hear first from Julia Alojamento, who is a candidate for seat number 19.
Well, thank you very much, and thank you for being here today. You asked some very good and challenging questions, and I hope that we were able to satisfy you with our answers. I hope what you take away from this is that a judge is really important, and it is important for us to pick our judges as someone who would be ethical and fair and experienced. And I think that my reputation in the legal community and at the community at large is as someone of that nature. I do have very broad experience, as I mentioned, having been a deputy district attorney for the past 12 years, really working to keep our community safe, both as I prosecute serious criminals, but also in the role of crime prevention, especially for youth. I also do have experience on complex civil litigation, so I would have no problem if the court decided to put me in the civil courts. And of course, because of my experience in domestic violence and the juvenile courts, I'm very familiar with many of the issues we've been talking to regarding families, and so if the court decided to place me there, I would also have that experience. I have a very strong educational background, graduating cum laude from Hastings College of the Law, and graduating Order of the Coif, and also went to UCLA where I graduated magna cum laude with departmental honors. And I really tell you that not because necessarily that's what makes a good judge, but so that you can see that throughout my entire life I have worked very hard to get to where I am. And if you were to elect me as judge, I would continue to work hard to serve this community. I would be honored to serve the community as a judicial officer, and I think my broad support from judges, attorneys, community leaders, elected officials, the Santa Clara County Bar Association and other bar associations, and all law enforcement agencies throughout the county should show you that I have the strong support based on my reputation and experience to date, and I would take that to the court. Thank you.
Thank you. We'll now hear from Vanessa Zecker, who is the candidate for seat 11.
So thank you very, very much for the wonderful questions that we received today. These questions are helpful to us in getting us to think about the issues that are important to you as voters. I hope that I have demonstrated to you through my answers to the questions that I have broad experience in all areas in our court system, in which I would be sitting as a judge. Family court starts the process for many families ending up in other systems within our court system, and the mental health and substance abuse and other issues that I deal with on a daily basis certainly impact all areas of our system. As an attorney for 22 years and a business owner for 16, I am familiar with most issues related to employment and those types of issues, and I bring that to my skill set as well. My endorsements, I believe, are what I am most proud of. They are broad-based endorsements. I have over 55 judges and commissioners who have endorsed me. The 2 prior elected district attorneys have both endorsed me. And I have law enforcement endorsements, including the San Jose Police Officers Association and Sheriff Lori Smith. I am extremely proud of the law enforcement credentials that I bring to this particular race. I am a Santa Clara native. I was born and raised in Santa Clara County. I attended schools here, and I attended Santa Clara University all the way through. My ties to this community go way back. I am a proud San Josean. My law practice has always been maintained in San Jose. I've been very, very interested in the issues and difficulties that our society faces in Santa Clara County all my life. I hope I've shown you through my answers that my judicial philosophy would be one of restraint. The law is meant to be followed. While judges are not supposed to be social workers, I agree to a certain extent with that statement, but I believe that judges are supposed to bring an element of compassion and understanding to what they do when they're exercising discretion. So the familiarity with the underlying issues that created the problem to begin with are something that I believe are very, very important to a judge.
Thank you. Next, we'll hear from Thomas Spielbauer, who is a candidate for seat number 7.
Well, I bring with me a tremendous life experience. Like I've indicated initially, I've been a lawyer for 32 years. I'm over 60, and I've seen a lot. I grew up in the 50s, and then I saw the transformation of society in the 60s and 70s, and so I bring with me a broad experience. The core thing, I think, is the philosophy, judicial philosophy that a person brings, and I think that I've demonstrated to a certain extent my philosophy. Anybody who says that judicial philosophy isn't important, or anybody who says that all judges are the same, that you just follow the law, that's just simply not true. That's sheer nonsense. A judge brings his perspective with him, and I've seen this very active, particularly in the civil theater, in dealing with foreclosures. If the burning issue, the sole burning issue today, and this is important, criminal practice, criminal law is important, but I don't see that today as the sole burning issue. And if that was the burning issue, I probably wouldn't be sitting here. What I see is the economic issues that have descended upon us since 2007, 2008, 2009, the bailouts of the banks, the impact on society, joblessness, loss of investments and loss of retirements. And then we start to look at the export of our industrial base overseas, all of which is going to have an impact on the lives of people. And you say, well, geez, this is too big of a picture to come in front of a judge, but it's not, because these issues, these economic issues, do present themselves in front of a judge, be it on the criminal side or particularly on the civil side, when these issues do come as a result of what our society is experiencing.
Thank you. Next year from Tim Pitzker, who is a candidate for seat number 11.
Yes, I'm going against Ms. Zecker, and I have to tell you the only reason I'm going against Ms. Zecker is because the other 2 DAs took the other 2 spots, and I didn't want to run against another DA. So I have to say also that I did some checking up on Ms. Zecker when I first got started here, and she is actually an excellent lawyer. One divorce lawyer told me that he does not want to ever go up against her in court, so she's a really good lawyer. So folks, you have a choice. You have a choice to make. You can vote for me, a person with 26 years as a veteran prosecutor, serving you, keeping the streets safe, making your home safe, or you can vote for Ms. Zecker, who spent the last 16 years as a family lawyer, predominantly doing divorce law. So that's your choice. Thank you very much.
Thank you. Next we'll hear from Bob Commerce, who is a candidate for seat number 19.
Thanks. I think you have a pretty clear choice here for office number 19. I'm a civil practitioner with 23 years seniority. I haven't just worked on cases. On every case that I've been on, I've been the lead lawyer for 20 years. I haven't just been somebody that worked on a team of a bunch of people or third person down carrying the briefcase. I've been the guy that made all the decisions and all the arguments and either won the case or lost the case on the strength of what I did. The other thing to say about me is that I've got educational credentials that are on the website. Please look at the website. It's really, I'd really rather talk about my endorsements here. I'm endorsed by Labor. The AFL-CIO Labor Council endorses me. I've been endorsed by the Rainbow Committee of the County Bar. That shows that they trust me to protect the rights of minorities, and that's something that I will do. I'm endorsed by 3 of my opposing counsel. These are senior, very respected senior lawyers in the bar. Craig Needham is a statewide name in civil consumer protection law. Byron Foster is one of the most prominent personal injury attorneys in Santa Clara County. They've all endorsed me for this office. I'm endorsed by law enforcement officers. I'm endorsed by past and present criminal prosecutors. No one who knows my history should seriously have any question about my willingness or ability to protect the victims of crime in this county. Beyond that, I offer 40 years of leadership, and I plan to be a leader not just in the court but outside the court. You need to realize that 36% of the sitting judges in our county are former district attorneys. 48% of the sitting judges in our county were involved with the criminal justice system either as a district attorney, a public defender, or a law enforcement officer. So when your choice is civil or criminal, and I respectfully request your vote for me as a former civil practitioner. Thank you.
Thank you. And Joanne McCracken?
Thank you. Thank you all for your questions and for your time this afternoon and for being interested in the judicial races. As I mentioned earlier, I bring 24 years of legal experience. I spent most of those 24 years prosecuting the most serious offenders in Santa Clara County: murderers, rapists, gang members, people who have committed those crimes. I have very broad experience in the law. In my years as a trial attorney, I am very proud of the fact that I worked very hard on every case, took every case that came before me very seriously, and I have never lost a felony trial. I devote, as I mentioned earlier, significant time to education, to teaching others, to lecturing, to spending time in significant volunteer efforts. I work with 5th graders and I've done that for 10 years. And I mentioned my work with the Salvation Army with domestic violence offenders and victims. I think it demonstrates a strong commitment to the community. I too am very proud of my broad endorsements, and my flyers are outside. You can look at my website and see who my broad endorsements are, but I have been endorsed by every group that has, to my knowledge, that has solicited, that has interviewed the candidates in my races. I've been endorsed by Bar Association, the Santa Clara County Bar Association, the Minority Bar Associations, various groups that I put there, judges, community leaders. Every elected official that has chosen to endorse in my particular race has endorsed me. As I said, I'm not aware of any endorsements that my opponent has at this time. I'm committed to the community. I'm ethical and fair. I am a tough prosecutor, but I have a compassionate heart, and I will serve you very well as a judge, and I would appreciate your vote. Thank you.
Okay, thank you, and I think we all want to thank you for your dedication and your willingness to run for public office. I want to thank the many volunteers who've helped make this program a success. I want to thank our audience for your attentiveness and your stimulating questions. And now I guess I get to turn things back over to Phyllis for some closing remarks.
Thank you, Ellen, for being our moderator this afternoon. You did an excellent job. Thank you, the candidates, for participating in a lively discussion. You didn't think it could take 2 hours, but it did. And we appreciate your being here and taking your time. and I'm sure that will help when we make a decision on June 8th. I want to thank Pat Bendikite and Veronica Tincture for putting so much time into presenting this event, and also to Relly Davidson for keeping us on time, and to the candidates for watching what she was doing and not pushing her beyond her limits. But thanks to the question sorters, Carol Stevens and Trina Levicek, and also to the readers, question collectors, Lee Sendelbach, Nancy Olson, Barbara Klein, and Pat Bendikite. All of you were great in making this forum work. It takes a lot to put it together. And thank you to the Media Center for the work of recording this event and putting it on the media and streamlining it as well. Don't forget Smart Voter for more information, and don't forget to vote on June 8th. More voter information is at the back of the room. Actually, it's out here in the lobby. It got too windy to leave it outside. It would have gone away. And so that you look for any of the information with our candidates. Stay and talk to our candidates for a few minutes. I'm sure they'd enjoy that. Good afternoon to everyone, and thank you for coming.